Hi, and welcome to this latest immigration law update video. In this video, I want to look at one of the general grounds for refusal in the immigration rules, which crops up quite often in entry clearance cases. That's Rule 320.11, where an applicant has previously contrived in a significant way to frustrate the intentions of the rules. So I've called this video Forever Frustrating, because this rule can be a frustrating provision and provide difficulties in entry clearance applications and appeals. I've also found of late, actually, that along with this rule, entry clearance officers on the same basis have been refusing under, I think it's SEC 1.5 of the suitability provisions, on the basis that somebody's presence is not conducive to the public good on the same grounds. So this rule often comes up in a situation where you have, say, a couple in the United Kingdom, they've got together while one of them is an overstayer. They've made an application and perhaps that's been unsuccessful. So they've made a decision for the applicant to voluntarily depart and apply for entry clearance on the basis that he or she meets all the requirements, substantive requirements of the rules. So the finances are there, the English language are there, the relationship has been previously accepted as genuine. And then the entry clearance officer refuses under 320.11. Now, notice the wording of this rule. It's where the applicant has previously contrived in a significant way to frustrate the intention of the rule. So it's quite a high hurdle. It's one of the general grounds for refusal. They're found in Part 9 of the immigration rules, the suitability requirements of Appendix FM. The visitor rules also have their own suitability provisions. And the burden of proof is ultimately on the respondent, so the Home Office or the entry clearance officer. In this case, it would be the entry clearance officer. So there's got to be overstaying, a breach of a condition, being an illegal entrant or using deception, and aggravating circumstances. Now notice the aggravating circumstances listed: absconding, not meeting temporary admission requirements, etc. These are just examples. This is not a closed list, but the entry clearance officer has to show something from the first list, Roman 1 to 4, and these aggravating circumstances. But as you'll know, Part 9 of the immigration rules has mandatory grounds and discretionary grounds, and this is a discretionary ground for refusal. So even if this conduct is made out, the entry clearance officer still has to weigh all the relevant circumstances in deciding whether to invoke the provision. Now, the leading case on this goes back to 2010. It's PS India. Now, it might be said, oh, that's out of date. You can't rely on PS India. I don't think that's right, because the version of the rules, the version of Rule 320.11 at the time of PS, the only difference now is what was guidance at the time of PS has now effectively just been embodied in the rules. So it's addressing the same situation. Now, in this case, Mr. Justice Kenneth Parker said it was unclear whether the entry clearance officer had addressed their mind to the relevant question, whether Mr. S's circumstances were sufficiently aggravating to justify the refusal. That's what I said earlier. It's a high threshold. And had the entry clearance officer properly recognized that there had been a voluntary departure. So that's a significant point that should weigh in an applicant's favor against the use of this rule. And perhaps if you're advising somebody who's currently an overstayer in the United Kingdom, has perhaps tried an in-country application and that's failed on a spouse basis, the best option may be to make a voluntary departure now and notify the Home Office and record that a voluntary departure is being made in order to make an entry clearance application. And notice another relevant circumstance was that the voluntary departure was more than 12 months ago. So the couple had been separated for that period of time. And whilst there's no mandatory re-entry bans in spouse cases, clearly the fact that they've been separated, again, was a relevant circumstance. And we'll come back to the passage of time in a moment. And what Mr. Justice Kenneth Parker goes on to say is if the aggravating circumstances are not truly aggravating, there's a danger that people won't go back voluntarily, that they'll actually just remain in the United Kingdom unlawfully, and that'll be counterproductive to the whole purpose of the immigration system. So in this case, the tribunal found the balancing exercise, because as I said, it's a discretionary provision, hadn't properly been carried out. And all relevant considerations need to be weighed in the balance, including the Article 8 rights. Even if the Article 8 claim on its own might not be strong, they are relevant to the balancing exercise under the 32011 consideration. So all relevant circumstances need to be considered: the voluntary departure, the amount of separation. It's also worth doing a subject access request in relation to the applicant, because I've had them come back and show, well, actually the applicant was properly reporting throughout his time. So that's something that weighs against 32011. Or I've had a previous refusal letter that has shown he's complied with interview requests and the like, again, which would count against the use of 32011. Perhaps if the sponsor has particular needs or a disability or responsibilities caring for a child or for an elderly relative, that might be something that all weighs in the discretionary balance. Now, actually, if you look at the current Home Office guidance, which is general grounds for refusal, section 2 of 5, considering entry clearance, it says this: when an applicant has previously breached the immigration rules and or received services or support to which they were not entitled, you must consider refusing the application. When those circumstances are also aggravated by other actions with the intention to deliberately frustrate the rules, you must refuse entry clearance under paragraph 32011. I'm troubled by that because, again, it doesn't emphasize the importance of considering the discretion. This falls into the trap that was set out in PS India. So you can see why sometimes entry clearance officers are quick to refuse under 32011 and not consider all the discretionary factors. It's important, actually, when you're making an application for somebody who's gone back voluntarily, to address all this in your representations and say, look, there are good reasons in this case. While one, his conduct wasn't sufficiently aggravating to justify 32011, and in any event, there are all these discretionary factors that should be weighed in the balance. I think passage of time, look, when we looked at PS India, I said they'd been 12 months apart, but passage of time must be relevant. The longer somebody is back and separated from their partner, I think the longer they stay there, the less a refusal under 32011 is justified. And in a slightly different context, Azakane may be helpful. A case from the European Court of Human Rights. This was somebody who had a re-entry ban due to criminality, but that was an entry ban of limited duration. And in finding the decision proportionate, one of the things the European Court of Human Rights placed emphasis on was that it was a limited ban. So I think we can use that to say, look, 32011 can't be imposed forever. And the longer that somebody stays separate, the less the 32011 decision would be justified. So I hope those are some helpful hints on dealing with a 32011 refusal, or even avoiding one in the first place. You can address the particular conduct of the appellant in your representations, perhaps do a subject access request, emphasize that it's not significant and not sufficiently aggravating, and then address all the discretionary factors. And then if it is refused, these are issues that you can raise on appeal, and citing PS India and Azakane to try and secure a positive outcome, because often the substantive rules are all accepted and the only barrier to entry is this 32011 refusal. I should say also that if you get one of those suitability refusals that are tagged on as well, on that the presence not conducive to the public good, if that's based on the same grounds as the 32011 refusal, I think that really stands or falls with it, because usually the entry clearance decisions I've seen recently don't give any separate justification for that suitability refusal. It all really turns on the 32011 refusal. So I hope that's helpful. Thanks a lot.